Start. This appeal is preferred against the impugned judgment and order dated 18/9/2006 passed by the High Court of Judicature at Madras in SA number 780 of 2006, whereby learned single judge of the High Court dismissed the appeal filed by the appellants herein at the admission stage. Stop stanza. The case of the appellants in a nutshell is that the appellants herein are the daughters of late Shri T.G. Baswan, died on 29/12/1979, and late Shrimati Sundari, died on 22/7/1989, whereas respondent number 1 is the brother of the appellants herein. Late Shri T.G. Baswan left threatened properties consisting of agriculture land, item numbers 1 and 2, and dwelling house, item number 3. Later on, due to the irresponsible behavior of respondent number 1, suit properties at item numbers 1 and 2 were leased out to respondent number 2 to 4 herein during the lifetime of the mother of the appellants herein. Stop stanza. During the lease period, the mother of the appellants died. On the expiry of said lease deed, the appellants herein through legal notice approached the respondent number 2 to 4 to deliver the vacant possession of item numbers 1 and 2. In reply, it has been stated that the lands were sold to them by defendant number 1. Being aggrieved, the appellants instituted a suit being OS number 202 of 2003, praying inter alia for the partition and separate possession of the suit properties, which consisted of 3 items, namely agriculture land, item numbers 1 and 2, and building site with constructed building, item number 3, and arrayed the brother as defendant number 1 and lessees subsequent buyers as defendant numbers 2 to 4. The appellants herein were the plaintiffs in the original suit. Stop stanza. The trial court, after hearing the suit at length, dismissed the same wide judgment dated 28/9/2004, while holding inter alia that the plaintiff is the creator of the defendant number 1 and the plaintiffs, who, being the puppets in the hands of defendant number 1, are not entitled to any partition. Being dissatisfied, the appellants took the matter before the district judge. Learned district judge, wide judgment dated 14/12/2005, dismissed the appeal while upholding the decision of the trial court. Stanza. Feeling aggrieved with the decision, the appellants herein preferred a second appeal being number 780 of 2006 before the High Court of Judicature at Madras. Learned single judge of the High Court, wide order dated 18/9/2006, dismissed the appeal at the admission stage itself. Consequently, this appeal has been filed before this court by way of special leave. Stop stanza. We have given our solicitous consideration to the submissions of learned counsel appearing for both the parties and perused the relevant material on record. The short question that arises before this court is whether, in the light of present peculiar facts and circumstances of the case, any intervention of this court is required with the impugned decision of the High Court question mark over